So hi, today I'm going to share with you a recent decision of Honorable Supreme Court rendered on 13th May 2020 between Jagmail Singh versus Karamjit Singh pertaining to the admission of a Xerox copy of the will deed. Now the principle what Supreme Court created in this decision, which is a sourced from section 65 and 66 of the Evidence Act. Now section 65 of the Evidence Act speaks about the admission of the secondary evidence. Now coming to the meaning of what is the secondary evidence, you should understand what is the primary evidence. Now there are two types of evidence that is allowed in the court pertaining to documents. That's the primary evidence of the document, that is the original document. Now there could be circumstances where the original document may be lost or may not be in the custody of the person who is filing the case. There could be Xerox in his possession. So in those circumstances, the procedure that is prescribed in the Evidence Act is to give notice to the person in whose custody the original of the document is available and summon him to the court and come to the conclusion that the original is under his custody, and then allow the Xerox copy of the evidence. Now what gained importance in Supreme Court decision is that the Xerox of the will deed, which already established, here the appellants who approached the Supreme Court established that the original of the will deed was handed over to the revenue authorities for mutation. So based on the receipt of the original will deed, the revenue authorities mutated the documents, mutated the records of the revenue department. Whatever the land records are available with the revenue authorities, they were mutated. And based on that mutation, and after that they somehow misplaced the original will deed from the records of the Tehsildar. When they were summoned to the court, they could not deny that they did not receive the original will deed. And even the scribe of the will deed, that is the person who wrote the will deed, also confirmed directly that he wrote the will deed, and his evidence also could not be disproved by the persons who are opposing the admission of the Xerox of the will deed. And even the evidence of the revenue authorities was also not disproved. So the revenue authorities proved that the original of the will deed was given to them directly, because based on that mutation was done. Now they can't deny the receipt of the original will deed. And even the scribe of the original will deed also came and deposed before the court, and his evidence also could not be disproved by the parties who are opposing the admission of the Xerox of the will deed. So therefore the factual foundation of the original will deed, that is the existence of the original will deed, was proved based on these facts, based on the depositions of the revenue authorities and the scribe of the will deed. Even then the High Court denied the law that is available or mandated under section 65 and section 66 of the Evidence Act. Therefore Supreme Court came to the rescue and created a principle that if the factual foundation of the will deed is proved, and in the instant case on hand, the factual foundation, the existence of the original will deed was proved, or in other words, the defendants failed to prove directly or indirectly that the original will deed was not available. In fact, it was an admission taken by the revenue authorities indirectly that based on the original will deed only they made the mutation, they made the changes in the mutation. And based on this decision, based on this conclusion, Supreme Court created the principle that, now you have to remember the principle that the Xerox of the will deed, now it applies to all other documents also, but here in the instant case, the Xerox of the will deed can be admitted as evidence if the factual foundation of the original of the will deed is proved. The original has to be proved, and original can be lost or original can be in the custody of other person. then that person in whose custody the original is available must be summoned to the court by filing an application under section 66 of the Evidence Act. Or else, if it is lost, the police complaint must be given and the charge sheet must be filed, and that police officer, if necessary, must be summoned to the court. Based on the admission or the deposition of the police officer, the court can come to a conclusion that the original is lost. So either way, a document cannot be produced because it is lost or it is in the custody of somebody. Either way, both has to come to the court and depose and suffer cross-examination and inform the court that the original is available with them or the original is lost, and they could not give it due to other reasons. The reasons are not necessary here. The factual presence and availability of the original is necessary ingredient in proving this case. Here in the instant case, it was proved. Therefore, Xerox of the will deed was, the Supreme Court directed the Xerox of the will deed to be admitted into evidence, and that will again, the contents of the Xerox of the will deed will again suffer cross-examination. That is different. The contents will have to be proved once again. The Xerox of the will deed must be proved. The contents of the Xerox of the will deed must be proved. So therefore, based on this principle, it will be a guiding factor for all the courts in India to apply this principle of admission of secondary evidence when the factual foundation of the original document is proved. Okay, thank you. Thanks for watching. Kindly like, subscribe, share and comment. Bye bye.